Is your business protected against the threat of malicious litigation and frivolous lawsuits? Are you sinking company profits into marketing campaigns that do nothing to contribute to the growth of your business? Bottled Business Sense provides practical business perspectives that uniquely emphasize both legal and media marketing strategies to protect and ensure the longevity of your business. Now, whether you're trying to provide a startup business with some level of stability or an established business with foolproof asset and estate protection, or simply attempting to get a better return for your business marketing dollars, Bill Bernard and Rick Moscoso will expose potential pitfalls to ensure the security and growth of your business, free from unwanted expense and the threat of litigation. You'll learn how to implement marketing and protection tools equal to those used by today's most successful corporations. Let's join Bill and Rick for today's Bottled Business Sense show.
Well, good morning, everyone. It's Tuesday morning here, and we have another episode of the Bottled Business Sense show. I am Rick Moscoso, one of your co-hosts here in one of our studios, and in our other sister studio, my other co-host, Bill Bernard, is on the other side. How are you doing there, Bill?
Good, Rick. Thank you. Yes, we're back today, and happy to be here for another Bottled Business Sense show. To help our business owners move forward and prosper in their business. You know, we've spoken many times, Rick, about what you and I discuss on the show, and we try to provide our business owners with common sense legal and marketing principles that they can use to both protect and prosper in their business. And so that's what we're here for. We certainly don't have to. We certainly don't claim to have all the answers for everybody, but we're sure, at least, that we can fit you into a category of some sort. Should you choose to contact us and explore some more specific help further on down the line. So, with that said, it's a great day to be here. Subsequent to Super Bowl Sunday, we're geared up and ready to go, and today we're gonna talk about, Rick. You and I are both going to discuss issues that I think are plaguing, I think, some of our business owners out there, and we titled the show "Popular Things Employers Do to Get Sued." And you know, we've talked about things that are problematic for employers in the past and how they can get into legal trouble. But today we thought we'd put together a list of some of the more quote-unquote popular ones. They're ones that are popular in the sense that they seem to come up on the courthouse steps quite frequently, but they're obviously not popular to our business owners. So I thought we'd get started in talking a little bit about that, and hopefully try to prevent our viewers and listeners out there from ending up on the courthouse steps.
Yeah. You have quite an interesting list here, and for our listeners out there, as we go through the show, if you have any questions in regards to some of the tips that Bill's going to discuss, feel free to drop us a line at bottlebusinesssenseshow@gmail.com. We're all over social media. You can also tweet into us as bbsense, and we'd be happy to help you out. And if you need more in-depth detail, Bill's available to do that, and we'll give you his contact information towards the end of the show. So, with that being said, I'm excited to hear about some of these things that are on topic here for today.
Well, let's get started. I think one of the principal things that a lot of business owners tend to do is to classify all employees as exempt, whether they're exempt or not. Exempt employees get a salary. You don't have to worry about meal time, break time, overtime, all of the critical compliances that need to be put in place if you are a non-exempt employee. It's much easier to pay people a salary. At least some business owners think that way, and so they tend to do that. But under both state and federal law, certain types of positions may be exempt and others not. And so by merely paying an employee a salary, Rick, that does not guarantee that they're exempt. No, sir. They're going to have to be examined more closely, And if they are found to be non-exempt, then back pay for overtime could be owed them. There could be a fine. If you're not giving them their required meal times and rest breaks, you could get into a lot of trouble. So,
No, give the listeners a quick definition of an exempt and a non-exempt employee.
Sure, and when you look at exempt status, because whoever's not exempt is going to be non-exempt, right? So you look at typically three categories of exempt job duties. One is called executive, one is called professional, one is called administrative. So job duties of exempt executive, let's take that for an example. Because professional, we could talk about lawyers, accountants. We can talk about administrative work like administrative assistant who works for a high-level executive. So let's talk about executive a little bit and examine some of the job requirements or job duties to be classified as an exempt executive individual. You regularly supervise at least 2 or more employees. Your primary job is management of the workforce and or the job specifics of the job, and you have some genuine input into the job status of other employees, such as hiring, firing, making different assignments, that sort of thing. If you then move over into professional status and administrative status, you have some of those overlapping duties, or you work for someone who has those duties. So generally speaking, you're going to be looked at as exempt if you're in one of those classifications. If you're not in one of those classifications, you're going to be looked at as non-exempt, and then you're entitled to all of the requirements that state and federal law provides. And if you don't get them, the employer can be sued for not providing them. Okay. So I want to impress upon people that, a lot of times we tend to just easily find a way to make a person exempt by giving them a job title. Job title has nothing to do with whether you're exempt or non-exempt. Rather, it's an exploration or an examination of your primary functions and your duties that will contribute to that. So if in doubt, call an attorney, find out what procedure you should utilize, find out where you're going with this, because you want to make sure that these critical elements are provided to non-exempt employees. I will tell you now that more employers are challenged and sued over failing to provide overtime or the necessary meal breaks or rest periods than most potential lawsuits in the workplace. These are ones that come up very, very frequently, so you need to be aware of them and make sure you have the proper precautions in place. So the other thing I want to talk about that's in relation to that, in a way, is a show that we've done in the past, Rick, and that is the distinction between independent contractors and employees. Remember, I think it's interesting that if we start talking about independent contractors, we take the easy way out oftentimes. Business owners do. The independent contractor status is very convenient for the employer because the quote-unquote independent contractor, who may really be an employee, is going to make the employer happy. Why? Well, you don't provide workers' compensation insurance, no unemployment insurance, no state disability insurance, no paid family leave benefits to an independent contractor. So many times the employer will take the easy way out and classify somebody as an independent contractor. But remember, and by the way, then the independent contractor who's really an employee gets ticked off at the end of the year when he realizes he hasn't paid his taxes, but that he should have. So that employer needs to pay these things, and they need to make sure that they're on board. And remember, and you can go back and watch our other show on independent contractor, but if your work is a regular part of the employer's business. If the employer provides the tools and the resources to make sure your work is done, if he controls the majority of what you do in the workplace, you are an employee, not an independent contractor, no matter what the title is. This is another example, Rick, of where calling somebody independent contractor doesn't necessarily make him so.
Right.
Okay? Right. So we need to be aware of these things, because too often we throw around exempt, non-exempt, and independent contractor and employee. We throw them around loosely. And this is why it's so critical to have a lawyer on board. This is the thing that you need to realize. Have a lawyer who has flexible fees, who's willing to be your lawyer for your business, and if you have a question, you pick up the phone, you can speak to this lawyer directly. You don't have to go through 10 people, and you get the answer you need within a reasonable period of time. And I think I mentioned the story, Rick, where a client called me recently and said, a new client, and said, we want to bring you on board. We're with a big firm. We can't get the work done when we want it done. We are being charged outrageous fees, and we have no real personal contact. Can you help us? And I examined the situation, and within 24 hours was able to get back to them and tell them I could in all of those categories. So
that's great. It's not, this show is slanted more to what employers should not do. But in the case of just first example, and we've got a lot of examples here to run through. So just quickly, if you're an employee and you find yourself in a situation where an employer has misclassified you as an independent contractor, or the proper agreement hasn't been made once they start employment, what recourse does the employee have?
Well, the employee should go to whatever human resources department is available at the place of employment. If there is no human resources department, if it is not that type of organization that supplies one, even though they should, then you would go to your direct supervisor and then on up the chain until you reach the owner of the company. If those things don't work, you go and file a claim with the labor board, or you file a lawsuit if necessary.
Okay.
So that's what needs to be done there. Another issue that we find, Rick, is that employers don't bother providing training for harassment, workplace harassment, sexual harassment, discrimination to managers and supervisors. They just throw up their hands. They won't need that information. That doesn't go on in my place. No problem.
Now, I thought I would think that's a mandated thing here in California, or is that not right?
Well, it's mandated from the standpoint that, yes, you should provide this training, but remember, not everybody does what they're mandated to do. I mean, most lawsuits are premised on the fact that you don't follow the law, right? So when you think about it that way, everything's fair game.
So there's no check system for to make sure that the employer has done these things that are actually mandated for them to do?
No, we don't have an employer police system, just like we don't have mortgage police. You say that you're renting a home when you apply for a loan, and you put down a renter's name, and nobody comes back to check to see if that home's being rented and producing income for purposes of your refinance. It's kind of like that. There's no employer police other than what we talked about in our prior show, the EOC and the DFEH, the state and federal agencies that monitor these claims, but the claim has to be made. So, the best defense is a good offense when you are talking about discrimination and harassment. You should make sure that your first-line supervisors are trained because, if a supervisor does something, you can legitimately make a claim that supervisor was allowed to do it by the company ownership, that they were aware of these actions and that they let it go. You, on the other hand, should keep logs of everything that you do to implement training on your supervisors. Remember, you not only keep logs on your employees whenever you have a problem with them, or whenever you praise them, or whenever you interview them, you have that checklist, you have it in your drawer. You pull out that little list and you do your annual reviews with your employee. You have the same thing on your supervisors. I know this sounds like, the KGB here, but you got to have these things in place in today's world. And if everybody does something, the way they're supposed to, then it's a great list, and it provides a basis for a great review and a salary increase in many cases. So let's take an example. Supervisor, I don't know, Susie, is standing in the employee lounge when one of her employees, Frank, tells an off-color joke to Brenda, a new female employee. Because Brenda laughs, Supervisor Susie does not say anything to Frank, or to anyone else for that matter in the organization. Several months later, Brenda quits and files a claim against the company for sexual harassment. The lawsuit claims that the company permitted a hostile work environment that included inappropriate jokes and comments. Happens every single day, Rick. Where somebody's there, somebody laughs, and sure enough, they run into a problem, or they're let go for some legitimate reason, and they're coming back and filing a claim, and guess what? That costs money. Mm-hmm. Remember what I say, and you look in the Bottle Business Sense newsletter that I publish every month, you don't have to be at fault to be sued. But you can have the proper things in place to help you should that ugly occasion ever arise. Okay?
Right.
So that's one thing you need to do. You need to make sure your supervisors are trained. It's oftentimes overlooked by a lot of our business owners who have a growing business, who are following all of Rick's marketing tools, right? And the business is now growing, and now they've got employees and supervisors on board.
Right. Well, that's great. There's a lot of things that it sounds like you really have to be aware of as an employer, and really do your due diligence to protect yourself. And man, some of these things here on this list look like things that are just I can't imagine someone being that ignorant to do these things. But like you said, it happens all the time.
Well, many times, ignorance is bliss, Rick, and you think your business is going along fine. You don't prepare for the worst. I mean, we talk about that all the time. People don't get a business entity. Everything's going fine. They don't think they're going to be in any trouble. Look, we're not advocating that you have to be looking over your shoulder every minute when you're running a business, but you should be looking over your shoulder every minute when you're running a business. In the sense that you do it reasonably and legitimately, not because you're panicked or because you're afraid of everything that comes down the pike, but because you have planned, you have made sure that you're carrying out your responsibilities toward your business and toward your employees, so this thing can smoothly sail along in that protected bottle.
Yep.
Another thing people do all the time, Rick, is they let employees decide what hours they're going to work and how many hours they want to work each day. Look, I believe it. People do that. Oh, well, I can't. Can I come in this? Can I do this? Can I do this? Yeah, can I go sailing tomorrow? And I'll bring you back a big fish when I catch it. Most employers are restricted by laws to the number of hours they can work. Employees, I'm sorry, without payment of overtime. One exception to overtime laws, for example, in California, is alternative work week schedule. However, employees can't simply decide that they want to work 4 days a week, 10 hours each day. A valid alternative work week schedule requires that employers follow specific steps to institute such a program. That's far too involved for us to get into in today's show with the time we have allotted and the other things I want to cover here. But suffice it to say, you make up the time an employee works. You make sure you pay overtime if they work over that time, but don't let them decide, when they're going to work and how much time they're going to work. That detracts from your authority as the business owner or the supervisor, and that's one thing you never want to do. You always want to be respectful to your employees, but you never let them make those kinds of decisions. Decisions that affect your liability status should not be made by employees. Period. End of story.
Yeah, that's great. Well, that's good advice. I mean, if you do it any other way, you're just inviting trouble. It sounds like
you're just inviting trouble, Rick. You really are, and that's where I would do. I would utilize, if it was me, I'd utilize Rick, and I would do videos on these topics, and have your employees watch these videos, and have them really hone in on some of the specifics, because you can condense these videos down into very short, succinct messages, and people will watch that and pay attention to it, especially if it's coming from somebody in a position of authority within the company. It's a lot, sometimes a lot more juicy than just reading it in a manual. Although you should have the manual and make them take it, it never hurts to provide this additional training.
Yep. Well, that's great. Before we get into the back half of the show here, we have a new sponsor here on the Bottle Business Sense show, and Bill, why don't you share some information here on the Home Mag?
Yes, the Home Mag. The Home Mag is a great publication located in Irvine, and they basically serve all of Orange County. And basically, you have your business. You provide photographs of your business, the service or product that you market. It's placed in the Home Mag, and that Home Mag does the advertising for you by stretching out its long arm and providing this magazine to all over Orange County and beyond, actually. And you might want to find out what the publication areas are, so your product you can hone in your product or service if you're looking for a specific niche. But the Home Mag provides these services. They're very reasonably priced, and they have a great reputation in the community for getting a lot of success pointed in the direction of the people that advertise in their magazine. So please contact the Home Mag at your convenience and check them out and see if this is part of your marketing plan, and check with Rick on that, because he can help you with this marketing plan, and he'll certainly recommend the Home Mag. And where can we get a hold of the Home Mag, Rick? Where are they located?
Yeah, you can. The Home Mag's located at 18001 Sky Park Circle, Suite H is in Harry, in Irvine, California, 92614. Their phone number is 714-881-4700. And their website here locally in Southern California is thmsocal.com. Or if you're in another area outside of California, you can go to thehomemag.com.
Great, and I know the owner, Ralph Harris, very well. He and his staff will take great care of you, believe me. So check him out, guys. Okay. One of the things I find employers do quite often, believe it or not, in fact, I was one time I was leasing space in an office where the owner of the building that I was leasing space from actually did this right before my eyes, which I was amazed at. But he terminated an employee who took a leave of absence. Specifically, in this instance, it was a pregnancy leave. It's too much trouble for me to administer these leaves of absences, and who knows if the employee is going to return. That's the position that a business owner will sometimes take. Look, employees have legal protections for various reasons when they're away from work: workers' compensation, disability, pregnancy, family and medical leave, military leave, jury duty. The laws are rampant with retaliation claims for firing somebody when they're on one of these leaves. If you terminate an employee while the employee is on a protected leave, or soon after the employee returns to work, you will have to provide you will have to show proof that the termination was legitimate. Non-discriminatory, a legitimate non-discriminatory business reason. You better have that file I talked about earlier on this employee, and you better pick a time when I would never do it when they're on leave or just coming back from leave. But believe it or not, it's something that happens frequently. It does, and you're playing with fire when you do that.
Yeah, something like that just doesn't make sense why you would even want to take the risk of putting yourself in that position as an employer.
Right. People I don't think they consciously think of these things. That's what the show's for, really, Rick, when you think about it. We're here to provide you these little tidbits so you can jot them down, or you can go back and mark where the show is and watch it at your leisure, or record it and keep it in your filing system or toolbox, whatever it is, so you can have these things available to you, and you're aware. This whole show really is about awareness, and that's what we're trying to provide. Don't give employees their final check if they fail to return company property. Sometimes employees who quit are terminated and often don't turn in company property, such as laptops, cell phones, right? Pagers, uniforms, tools, holding their final paycheck until such time as the items are returned. That's what happens. The final paycheck deadlines carry a hefty penalty. So, if an employee is terminated or quits and gives more than 72 hours notice, that's calendar days, not business days, the employee's final check must be ready on the last day of work. If you terminate an employee, the final paycheck is due the moment the words "you are fired" come out of your mouth. The final check must include payment for all hours worked through the last day, including any overtime and any accrued or unused vacation. Can't be much simpler than that.
And
Okay?
what if an employee quits? What's the when do they have to turn over that last check?
Well, if an employee quits or gives more than 72 hours notice, the employer's final check must be ready on the last day of work. Okay?
And if not, inside that 72 hours?
Well, then, if the employee quits and doesn't give 72 hours notice, then you typically you're provided that amount of time to provide the employee the paycheck. So you just go by that reasonable amount of time, and look, if it's again, if it's me and you want to get down to brass taxes here, I pick up the phone, I call my accounting department, and I say, have that check on my desk within the hour. Why screw with it?
Yeah,
that's the way I would approach it.
And how does the employer handle a laptop? Say, for example, they have some assets of the company.
Well, if they don't give them back, well, then you're going to have to take action to get them back. I mean, if they're valuable enough to you where you want to bring suit against the employee, then you do that. You just simply do that, Rick. And again, to your question more specifically, I think I answered it, but I want to make sure everybody's clear. If an employee quits without giving 72 hours notice, you have the 72 hours to prepare the final check. Okay. Now, next big no-no. Oh boy, here we are, Rick. Do not provide loans to employees and deduct the money for the loan from their paycheck each pay period. Boy, oh boy, oh boy, oh boy. California Labor Code permits deductions authorized by law. Okay? By law. What's a major one? Well, health benefits, right?
Right.
But no, they don't. The Labor Code doesn't provide for a loan system. State and federal law require certain withholdings. Social Security, state disability. Oh, right. 401k, if you signed up for a 401k. Deductions for loans made to employees are not permitted and therefore cannot be made. If you decide to loan money to an employee, good Lord, guys and gals, why would you? But if you decide to loan money to an employee or make any other type of payment for which the repayment may be required, you should have the employee sign a promissory note and have it reviewed by your legal counsel. Period. End of story. Got to do this.
That makes total sense. Let me ask you this: What if?
And people do this, Rick. People do this. People loan money to their employees. They think. Why? Because sometimes they think they got them. Now they got a hook in them because they were nice enough to loan them money. These guys are going to do whatever they want. Don't think that way. Go ahead. What was your question, Rick?
That's amazing. What I don't know if this applies or it's the same type of situation, but let's say you're in a sales position and you take a draw or an advance. What is that? Would that fall in the same type of situation, or is that a little bit different?
No, usually if you take an advance, number one, it's permitted by the company, and that advance is going to cover a specific period of time over which you will not be paid until the next regular pay period comes about where you're entitled to be paid. So there's an employer is generally not going to charge and shouldn't charge any interest on an advance because that's salary, that's not a loan. When you take an advance, you're taking an advance on your salary, not a loan. Those are two different things. A loan is money that you're not entitled to. An advance is money you're going to be entitled to. You're just taking it earlier than you would normally take it.
Okay. All right. That makes sense.
Next one. We got a couple more here that are very important before we close the show. We talked about non-competes specifically in another show, devoted an entire show to non-competes. They are prohibited in California with a few exceptions. Those exceptions are discussed in our prior show. Go back and look at that show if you want to find out about those. But prohibiting an employee in California from working with someone else is limited because it infringes upon the ability to work and earn a living. You cannot force an employee, okay, to stay with you, nor may you prevent them from earning a living if they choose to leave your company. And what you can do is have them sign a proprietary agreement which prohibits them from divulging trade secrets or trying to steal some of your other employees. But you can't have them sign a non-compete because if they challenge it, it's going to cost you money and it's going to be wiped out because unless you're an owner of a company that leaves, you can't prevent an employee from leaving your company, going to another company and making an honest living. They have the right to do so.
Okay.
So don't use non-competes inappropriately.
Now that's a little bit different though than what I understood from the previous show. Let's say you're at a C level in a company or an executive of a company that. And then you decide to go elsewhere, or you have the desire to go to the competition for some reason. Wouldn't a company sometimes have safeguards where they would have to sign they would require an executive like that to sign a non-compete, especially, a high-level CEO or a high-level CE position?
Well, as I said, if you have an ownership interest in the company, you can't really prevent. And remember, oftentimes executive management are employees of a company. For example, I own WFB Legal Consulting Incorporated. I'm the president of the company, but I'm also an employee. I just happen to also own the company. So if you are a high-level employee, if you don't have an ownership interest in the company, or if you don't have enough input in the company to provide some influx of information as to how the company is operated, such as maybe a CEO or a president of a company, well, then you can't force a non-compete. Otherwise, you can force a non-compete within a reasonable period of time and within a reasonable distance as the basic part of the premise for which you were hired, because you're going to have direct input on how this company is run, and or you're going to have an ownership interest in the company, or an interest in the company that rises to the level of being able to control what the company does or doesn't do. So those are very limited but yet different circumstances, Rick, than just forcing an employee to sign a non-compete.
Okay, that makes total sense. Thanks for clarifying that. And I think you have one more on your list here before we.
Yes, we do, and that is implementing. Yes, that is implementing a use it or lose it vacation policy. Okay, believe me, employers do this. Okay, not going to use your vacation, you lose it. Well, that's not permitted in the state of California. If employees have accrued vacation, it's a form of wages that you just can't take away. You can't take away their wages. You may place a reasonable cap on the accrual of vacation, which stops the accrual of vacation when a certain level is reached, but you can't take it away. So what do I mean by that? Let's take an example. The employer can implement a policy whereby you can have 2 weeks vacation a year, and you can accrue up to 4 weeks of vacation if you don't take it in 1 year. So the next year now you have 4 weeks. The employer implements a policy that caps the accrual at 4 weeks. So if the employee has 4 weeks accrued but unused vacation, the accrual of continued vacation stops until the employee actually takes the vacation. Okay? So remember, you can't take the vacation away, but you can put a reasonable cap on it. And that's going to depend on how much the employee is entitled to each year. So in our example, he or she is entitled to 2 weeks. You can put a cap on 4 weeks, saying you got the 4 weeks without taking vacation, but if you don't take it, it stops at 4 weeks until you start taking it. And then as you start taking it, the accrual process starts all over again until you cap out at a total 4 weeks. So you can make these reasonable implementations, but the employee has to know about it, and it has to be reasonable. You just simply can't take away the vacation by saying if you don't use it, you're going to lose it. That's wrong, and you're going to end up on the courthouse steps.
Right.
Okay? So I hope these tips, Rick, have helped our business owners understand that these are not only issues that that place them on the steps of the courthouse, but they're very, very popular. They're quote-unquote popular because they're oftentimes done in a way that allows the employer to believe, this is the easiest, most functional way I can handle this. And I'm just going to do it my way, and I'm not going to worry about the consequences. Mm-hmm. Well, again, if you're that kind of a business owner, you're going to have problems down the line in other areas as well. Be aware of these things. Jot them down. Watch our video, and if you need to, call an attorney and bring them on board and make sure that they're there to help you for in dealing with these issues.
Yeah. I mean, this list is amazing because it's I shake my head at some of these because I just think it's someone's got to be ridiculously stupid or ignorant to.
Well, no, it happens, Rick, because people sometimes want to take advantage of other people. And you look, I don't want to sit here and accuse business owners of being, having that frame of mind. But there are all kinds of people out there. We want to make sure that you're not the business owner who's not necessarily intending to do nasty things, but the business owner who hasn't yet been educated to some of these things. And you maybe have a new business, or you maybe just had an old business but are just starting to bring on employees. These are not things that you're typically dealing with on an everyday basis, and now you have to incorporate them into your business toolbox. And so we want to make you aware of them, so you stay away from the courthouse and you're able to concentrate on prospering and making that business sail smoothly forward.
Yeah, no, that's great advice. And folks, if you're in this situation, whether you're in a situation where one of these 9 topics is applicable to you, or if you're starting a new business and you need some legal counsel, Bill is a great place to start to get that information. He's an expert business attorney that can certainly point you down the right path. So if you need to take up some discussion with Bill, what's the best way to get a hold of you?
Well, I have 2 phone numbers. Both 949 area codes. The first one is 413-6535, 413-6535. The other number is 698-6222. That's 698-6222. The second number is my office number. The first number is my direct cell number. I give that out to all potential clients and to clients as well. You can look at wfblegalconsulting.com. And you can email me at bill@wfblegalconsulting.com.
Well, that's
Okay.
awesome. Great show, Bill. I appreciate your expertise in this area. It's phenomenal.
And great questions, Rick, and I'm glad we're able to help out our viewers and listeners. We'll look forward to another great show next week. In the meantime, we want everybody out there to forge ahead, be prosperous, and have a great business week. And we'll look forward to seeing you back here, same time, same place next week. Right, Rick?
That's absolutely right. We'll see you folks here on Tuesday next week at 10 a.m. Pacific time.
Take care, everybody.
All right. Bye-bye now.